Joining me now live is constitutional lawyer and senior lecturer at the Macquarie Law School, who has worked for the last 12 years with Noel Pearson, including on drafting for The Voice, Dr. Shireen Morris. Shireen, thanks so much for your time. As I said, you've been involved in this process. Why are you comfortable with the wording of the proposed amendment as it is?
Well, Kieran, thanks for having me. I'm comfortable with it because this started as a constitutionally conservative drafting amendment back in 2014 that was meticulously negotiated between Indigenous leaders like Noel Pearson and constitutional conservatives. And that drafting that was agreed back in 2014, almost a decade ago now, has over the intervening 9-10 years been streamlined, improved, debated and refined, which has led to the bill that we are now historically seeing debated in the Parliament today. And importantly, this concern about executive government is a very new concern. You know, critics and potential opponents had 8-9 years to raise these concerns. Some of the critics that we're hearing from now, in fact, over the last 8-9 years, defended the drafting in its various iterations that included executive government. They defended the drafting as legally sound and constitutionally conservative over these intervening 8 years. Julian Leeser wrote in a book in The Forgotten People in 2016, talking about Anne Toomey's 2015 draft. He said, this is the kind of clause that Griffith and Barton would have drafted had they turned their minds to it. Yeah.
Well, given that, though, that you mentioned there, that reference to executive government, and given the concern, as you said, that's been raised by Julian Leeser, but others, including former High Court Judge Callanan, that can be averted with a relatively minor change in the wording, can't it? Why not? Why shouldn't the government look at that?
Well, Kieran, the expert committee and the working group already made a very significant and elegant change to the wording before the parliamentary committee process started. Now, in response to these concerns about executive government, which in my view are very spurious and exaggerated concerns, which have been refuted by the vast weight of respected legal opinion. Nonetheless, to allay those concerns, the expert committee provided a tweak to subclause 3 in the drafting, which basically expanded Parliament's power to control all matters relating to the voice, including how the voice would interact with Parliament and the executive, and including whether the voice's advice, the voice's representations would carry any legal consequences or legal effects. Now, that was a really important change. That was a significant change, expanding Parliament's control over the voice and making sure that Parliament can control the legal implications of the voice's representations. Now, the fact that that change has not been noted by fearmongers who are still going on about executive government, even though the vast majority of legal opinion has declared the voice drafting legally sound, that tells you that no amount of tinkering with the voice wording at this late stage is going to stop the no case.
I'm almost out of time, but just quickly, I do want to ask you, though, the history of referenda in this country shows when you need an overwhelming majority, if not bipartisanship, overwhelming legal endorsement, again, isn't it worth making some late final change there?
Well, I think it would be better if we had bipartisanship, and I think it's highly unfortunate that Peter Dutton's Liberal Party has taken a very premature, hard no stance. But listening to Dutton's comments in the Parliament today, that just underscores that this opposition is ideological. The Liberal Party have decided to take a negative stance on this issue of national significance, and no late tinkering to address these spurious concerns about executive government is going to bring the Liberal Party on side. And I think we do have the vast majority of legal opinion, saying that the drafting is legally sound. Respected people like Hayne, French, Professor Anne Toomey. So that's really important to remember. I don't think you can expect lawyers to agree on anything at the end of the day. There always has to be a little bit of dissent. But the fact is, over 9-10 years, this drafting, which started as a Conservative compromise, has been refined and improved, and we are now arrived at an elegant solution that is being debated by Parliament, and I look forward to it passing.
Dr. Shireen Morris from Macquarie Law School, thanks, appreciate it.
Thank you, Kieran.